All right. Good morning, everybody. My name is Tom Sheehan, and I am the Director of Membership Solutions at Catapult. I'm very pleased to have you here with us today and hope that it is a valuable learning experience for you. On April the 23rd of this year, the Department of Labor released the final rules on the new salary threshold for white-collar exemptions under the Fair Labor Standards Act. The first increase goes into effect on July the 1st of this year. Our aim today is really to make sure that you understand what this means for you and what you need to do to get ready for this potential change. Of course, we always have a caveat for you. There's always the possibility that this could be challenged. So we're not suggesting that you do anything at this point other than to create your plan and be ready for potential changes. We don't want you to be caught flat-footed. During this presentation, we will be referring to a new toolkit that you can find on our member portal called the Hub. And it launched yesterday to rousing reviews. And again, for our members, I highly encourage you to get into the Hub and locate all of the resources and tools that are available to you, as well as join our new member community. Presenting today will be Linda Hunter, Carol Dixon, both HR advisors, and Jackie Esposito, who is our compensation consultant professional. And with that, I am going to turn it over to Linda. Linda?
All right. Well, thank you, Tom, and welcome, everyone. We're really glad that you're here. Thank you so much for joining us. For those of you who have been around for a while, you may remember our old Answers at 8 sessions, and this session of Thinking Differently is going to feel very familiar, very similar to that format. So as Tom stated, our aim today really is to get you up to speed on what the new salary thresholds are and give you some practical steps on what you need to do now and in the future to be able to kind of move forward. So just a couple of quick housekeeping notes. Remember those, right, from Answers at 8. If you have any questions, go ahead and put them into the chat. We'll monitor the chat, but we're probably going to hold most of the questions closer to the end. We've designed this session to allow for a Q&A style at the end. We're also recording this session, and that will be sent to you after today's presentation. You will also notice that we will be placing some links in the chats for you. And as Tom referenced, we do have a new landing spot for you, if you will. So to get to the links that we are providing, you will need to be logged into your Catapult account. And then you will be able to access the Member Hub. And it's very easy to get to from the main Catapult site. You just go up top, you click on Member Hub Login. First time you do that, you'll have to agree to the terms and conditions. But after that, single sign-on, easy peasy. Once you do that, you'll see a link for HR toolkits, very similar to what you've seen on the old website. And the very first one that comes up is the new DOL Overtime Rules Toolkit. And you really will find a lot of the tools and templates that we're talking about today located there. But of course, any questions, any issues logging in, you know what to do, right? Give us a call. All right, so with that out of the way, let's get started. Jackie, can you tell us a little bit about how we got here?
Of course. Thanks, Linda, for kicking us off. Hi, everyone. We have a big group today. I know we all love change. And so today, what we really wanted to do is give a brief history of the FLSA and then the changes that we're seeing. So we all know that under the FLSA, the Fair Labor Standard Act, roles are either exempt and do not get paid overtime or non-exempt and are paid overtime. We often refer to this as what is the position status, right? So for jobs to be exempt and for your positions to be exempt and not paid overtime, the role must, one, meet the salary level threshold minimum, and this is required by the Department of Labor to be excluded. Two, be paid on a salary basis meaning an employee receives a predetermined amount of fixed compensation each regular period. So this compensation is not subjected to reduction of any sort of pay variation due to the quantity or quality of work, right? It's that regular standard pay. And 3, it must meet all of the job duty exemptions required by the duties test. While the duties test has not changed with this new regulation, this is a great time to really look at your job descriptions and the expectations and match it with the duties test, right? Make sure that you have your positions correctly classified. We here at Catapult have some resources to help you with this on our website. We will include these in the links. The first one is the new overtime rule toolkit that somebody will throw in the chat for us. It's a great guide to gauge our current employees and their status to see where they should be. Second, I always like to advocate for, it's really important to gauge our new employees against our current employees. Pay equity, right? To ensure that alignment, not only with this new ruling, but also compared to your current and new employees. So we have a template that we'll put in the chat for this as well. So the main area of change is this salary level, which the FLSA ruling has increased in 2 increments starting July 1st of 2024. So on July 1st, the new minimum amount an exempt employee can make is going to $844 a week, which equates to $43,888 annually. This is going up from the current state of $684 a week, $35,568 annually. The formula that was used to determine these increased calculations was the same formula that was used back in 2019 when we had this increase. Because of this, we don't think this amount will be changed. So we really encourage you to be ready to go for July 1st. On the other hand, the next increase in January 1st of 2025, as well as all future planned increases on a cadence of every 3 years, is based off of a different formula. And because of this, we do expect that this will be challenged. But if nothing changes, and if this is challenged, but it holds to be true, then on January 1st of 2025, we need to have our exempt employees making a minimum of $1,128 a week, $58,656 annually. So current state, we got to get ready and be prepared for your exempt employees to meet that January 1 threshold of $844 a week, $43,888 annually. The threshold exemptions for our highly compensated will also be increasing. You can see on the slide from $132,964 to $151,164. If everything holds true by January 1. It's important to note, looking at those numbers for a lot of us, for a lot of organizations that have, lower level salary positions, not lower level, but entry level salary positions, this number is a little intimidating, right? Well, it's important to note that 10% of that number can be paid using non-discretionary bonuses, right? So things like incentive, commission, 10% of that weekly pay, that salary, can be made out of non-discretionary bonuses. And this holds true for all categories, right? Administrative, professional, creative, executive. So keep that in mind. As of January 2025, right, using that 10%, you can make up to $112.80 a week in bonus, non-discretionary bonuses, right? So the new law also dictates that these thresholds will automatically update every 3 years. So we have our first one starting January 1. We have our second increment. First one starting July 1st. We have our second increment January 1, and then the next increase will not be until July 1st of 2027. But again, all of these future increases are based off of this new formula. So we might see some changes to what these increases will be every 3 years. So now that we know all of this, kind of like the lowdown, overview of what we're seeing, what do we do? How do we get prepared? I'm going to pass it over to Carol. She's now going to help us all with next steps.
Yeah, so thanks for that insight. It's always helpful to see like where we've been and where we're going. And so as we talk about next steps, the first thing we're going to do is review our current pay practices and FLSA classifications of the jobs. So like Jackie said, this is a great time to make sure that your employees are properly classified. And that means looking at the salary as well as the duties. Now, the reminder I like to give everyone is that you can't rely on just the job title or job description alone. What the person does is most important. So when you're reviewing your positions to determine if they can be classified as exempt under the FLSA, there are several white-collar exemptions that could apply. And we're going to place a link in the chat that takes you to the DOL fact sheet. So you can refer to those as you go through that exercise. Now, there were 3 white-collar exemptions that were impacted by this new rule: the executive, administrative, and professional exemption categories. Now, we're going to focus on 2 of those 3 exemptions for today's purposes, the administrative and executive exemptions. So let's take a look at those duties. And again, as a reminder, as Jackie mentioned, all of the duties must be met for the exemption to apply. So let's start with the executive exemption, and let's talk a little bit about those criteria that have to be met. So first, it's that they have to be compensated on a salary or fee basis. You'll see that it says not less than $684 per week. That is the current rate. Just remember, that's going to be increasing as of July 1st. The employee's primary duty must be managing the enterprise or managing a recognized department or subdivision of the enterprise. The employee must customarily and regularly direct the work of at least 2 or more full-time employees or their equivalent. And then the employee must have the authority to hire or fire employees, or their suggestions and recommendations as to the hiring and firing and promotion of employees have to be given what they call particular weight. Now, in the case of this executive exemption, the employee doesn't have to have executive or manager in their title to qualify. Remember, I said what they actually do impacts their eligibility for the criteria. Where we see some employers misapply this exemption is around the terminology of primary duty and customarily and regularly. The DOL defines primary duties as their main, major, or most important duty that they perform. And then they also define customary and regularly as work normally and recurrently performed every work week. So when we review the position for this exemption, some items to consider are the importance of their exemption duties compared to any other duties they may be performing, the amount of time they spend performing that exempt work, and their relative freedom from direct supervision. Now, for those of you who have managers who also perform non-exempt work, this can get a little tricky. And so you'll need to take a close review of the duties they perform if you're considering this exemption. So an example is if you've got a store manager who spends, let's just say 50% of their time on customer service, 30% on cleaning and 10% on merchandise receiving and stocking. When you look at the cumulative duties for the position, that doesn't leave much time for performing managerial duties. So they likely wouldn't meet this exemption criteria. So just keep that in mind as you're reviewing your roles and the work that they perform. And if you have questions or you're unsure about the application of this exemption, you are always welcome to reach out to us here at Catapult and we can help you navigate that review. So let's take a look at the administrative exemption criteria. Again, we go back to that salary piece. Again, just the reminder that 684 is increasing July 1st. But for this particular exemption, their primary duty has to consist of performing office or non-manual work directly related to the management or general business operations of the organization or the organization's customers. Their primary duty has to also include the exercise of discretion and independent judgment with respect to matters of significance. Clear as mud, right? We all struggle with that second criteria. Primary duty, including the exercise of discretion and independent judgment with respect to matters of significance. So the DOL does give us some clarifying information on the fact sheet and within the regulation for this exemption. But overall, let's be honest, the analysis is still just a bit subjective. So we're going to put some links in the chat that include some examples that may help you in navigating this particular exemption requirement. Let's talk for just a minute about some of those factors that the DOL says should be included in your review. When we're looking at exemption under the administrative category, we're going to look at whether or not that employee has the authority to create or interpret policies or operating practices, whether they have the authority to waive or deviate from established policies and procedures without prior approval, and whether they perform work that affects business operations to a substantial degree. They also remind us that the exercise of discretion and independent judgment is more than just applying well-established procedures or standards. So that's a big differentiating factor when you're looking at your positions. An example they provide, just as a point of comparison, is someone who does comparison shopping for a retail store who merely just reports to the buyer the prices at a competitor store, versus the buyer who evaluates that information and then sets the prices for the organization. So I know you don't all have shoppers or buyers in your organization, but it's just a way to help us differentiate those criteria. Now, the links in today's chat and the resources that Linda and Jackie and I are mentioning are all going to help you in honing your focus to the positions and the employees that are affected by this new rule. Once you've reviewed the classification for your positions, you may find that you need to change the FLSA classification, especially if you find that they're perhaps misclassified as exempt. If so, you'll want to make changes in writing and provide at least one pay period's notice before the effective date of the change to your employees. Not to worry though, as always, we have a template to help you in the toolkit, that link that was provided earlier for you. And so as mentioned earlier, the duties test is just one piece of this, right? So, you know, Jackie's already talked to us about some salary pieces. I've addressed the duties test, but now we're going to talk about that salary basis and salary level. So Linda, give us a little bit more insight into how that comes into play for our next steps.
Yeah, sure, Carol, happy to. So just to reiterate for everyone listening, the duties test is not changing. It is as it has always been. We just think this is a good time to pull it out, dust it off, and take a look and make sure that you've had it, that you have it right. And if you don't, this is a great opportunity to make those changes. But what is changing are those salary thresholds that Jackie went over with us. So we really need to do that analysis to make sure that any employee that we're going to fit into one of those exemptions that Carol talked about really does meet those new salary thresholds. And really, the best way to do that is by using some sort of an analysis tool. So in that toolkit that we have for you, there is a spreadsheet where you can load in your current salaries and you can compare those salaries to both the new salary for July 1st, as well as against the new salary for January 1st. And we even added some flexibility in there so that you could look at any merit or other type increases you may be giving before January. So as you can see on this slide, it's just going to give you a good snapshot of where you are and what decisions you may need to make. You're basically going to have to do one of two things, right? You're either going to have to raise your minimum salary to the new exempt levels, or you're going to have to change that classification to make that person non-exempt. Now, one thing to keep in mind, and I know half of you, when you hear this, are going to be like, no, that's not true. But you can have people in the same role with different FLSA classifications, right? So Carol and I are both HR advisors, and we're not assuming there's any kind of pay equity issue. Maybe because of experience, we're a couple $1,000s apart. And one of us is under the threshold and one of us is over the threshold. It is fine for one job to be non-exempt without affecting the exemption status of the other one. So I know that's new news for lots of people, and I will be honest with you, it's probably new news for some of us on this call as well. But the DOL actually has an opinion letter on that, so we know that is true. Also, as Jackie mentioned, part of this new salary threshold can be obtained by using commission or non-discretionary bonuses. And just really quick, right? Like non-discretionary bonus is a bonus that's paid because the employee is doing something, meeting something. They have to do something to get it, as opposed to a discretionary bonus, which is the sun came out today and I feel like being extra generous and giving all my employees a sun bonus, right? They didn't do anything for that. So that would be considered discretionary. So for example, if you have someone that's paid $40,000 a year in base pay, and then they earn another $10,000 in commission or bonus, whatever it is, you have to get them to that $43,888 a year. 10% of that $43,888, which is $4,388, can be added to the yearly pay to arrive at that figure. That will get you to the July threshold. So I hope that makes sense. This has always been the rule, but so many people didn't realize it. But 10% of the new threshold is what you are allowed to use in commission or bonus to get to that new amount. Okay. So let's say you go through all of this and you have to decide, the classification, or do you need to reclassify someone to non-exempt? There are some other things that you really need to consider, right? One of the things is, how are you going to figure out what that new hourly pay rate could be? I mean, one way is you could just take their current salary, divide by the number of hours they work in a week, and get to that. But don't forget overtime. So you're going to have to pay 1.5 times the regular rate for any hours that are worked over 40 in a work week, right? So that could change that amount. And that overtime calculation does also have to include if you change somebody to non-exempt, has to include any of those non-discretionary bonuses, shift differentials, commissions, et cetera, that are paid. So that can actually make the rate, the overtime rate anyway, much, much higher. You also will need to decide if you are still going to pay bonus or incentive pay, or if you need to start paying bonus or incentive pay. So that factors into your decision making. If you change somebody to non-exempt, guess what they're going to have to start doing? Something they're probably not used to, and that is tracking their time. And that may require training. We'll talk a little bit more about that later on. You also are going to want to look at your benefit plans Do you have different benefits for both exempt and non-exempts? And if so, how will making changes affect that? Not just both on a psychological level for your employee, but also on an actual administrative level. How are you going to make those changes? And you also may need to look at policies that you have around equipment, right? Like who gets laptops, who gets cell phones, who gets those reimbursements, etc. So, Jackie, anything else you can think of when it comes to making these changes and what employers may need to think about?
Absolutely. I think Linda made a really great point that I'm going to reiterate. While there are restrictions for team members that can be exempt from overtime, you as an employer can choose to make a position non-exempt. So if I would always encourage to make sure you're paying attention to the market value of a position, right? We don't want a position to be under market and we just make them now eligible for overtime. We don't have to reach the 844 a week, right? But if you have folks that are salary that are under that threshold, we can say, even though they meet these duties tests, we're going to make them non-exempt, right? And we can have two different individuals for many different reasons into different classifications. So I think that's really important to reiterate. It's not as easy as, hey, we're going to make all these folks non-exempt. I think it's important to think about the morale, right? The engagement. I think that sometimes, being non-exempt, we have this stigma related to it, right? But it's really important to reiterate there is a potential for them to make a lot more, right? So take the status symbol away. The government is doing this. The purpose is because they want more employees to be eligible for overtime. That's the driving force behind this change, right? So we want to make sure that our employees know that they're valued, and that this is a standard mandated change, and that they have the resources available to them to communicate any concerns that they have to you or another appropriate person within the organization.
Yeah, I think that's really a good point, Jackie, and something that I say once a day, I feel like, is if you want to make your CEO non-exempt, you can. So any position can be non-exempt. We do have to look at the reasoning behind why that was done and understand that it really is that those changes really are being made for the majority of workers, not against them. But we also need to remember state law, right? So some states have higher levels that must be followed. North Carolina, South Carolina does not. But if you've got remote employees that are working in other states, you are going to have to check on those state laws, and you're going to have to offer whichever benefits are greater. So, I mean, I don't know off the top of my head, but I, imagine that some of the Northeast or Northwest states have higher salary thresholds. So I want to talk a little bit more about the training around if you are changing somebody to non-exempt for all the reasons that we've discussed. Just some things to keep in mind when you're putting that training plan together. So remember that this is a group that now is probably going to have scheduled hours. So they may not be used to that. They may be used to some more flexibility. They may not be used to time tracking. They may not be used to overtime approval policies. So to be clear, you are going, an employee, if they work overtime, whether you approve it or not, you have to pay them for it. But if you have a policy that says they have to get approval first, you can certainly performance manage them for a policy violation. You're going to have to go over with them timekeeping procedures. What types of systems are you using? And are you going to need to require any kind of training on that system? They may be used to using it on an approval level if they have direct reports, but maybe not on inputting their own hours from that perspective. What kind of record keeping requirements do you have? What is your company policy around meals and rest breaks? Do you mandate them? Do you not allow them? Again, state law can vary, but North Carolina and South Carolina, there are really no rules around meal and rest breaks. You don't have to offer them. If you do, yes, you have to fit into some criteria, but you do not have to. What are your policies on using personal devices for work? You know, do you have a non-exempt population that's not allowed to use their iPhone, but you rely on that iPhone use for your exempt? And you know, making sure that a new group of non-exempts understand that they can't work off the clock, right? This is hard. And, you know, for many of us, right, we're just going to check our emails real quick at night.
Mhm.
And, you know, 5 minutes turns into 30 minutes, which
Right.
turns into compensable time. And, you know, you have kind of a mess on your hands. So since that time now can be compensable, we definitely have to consider it. So just some points to think through when you are putting together a training plan to make those types of changes. Carol, final thoughts from you?
Yes. So let me drive home. Be ready, but don't do anything yet. Okay. So for any of you who were in the world of HR in like 2016, everybody had everything done and communicated. And then with just 7 days to go, like the law was pulled. And that was very hard to undo, right? So we want you to prepare your talking points, your communications, do all of your proverbial homework, right? Get your notification letters ready, pull together whatever training may need to be conducted. Then you're going to look at what date would allow you to give a full pay period's notice before that July 1st effective date. And you're going to use that as your communication date. You know, as Jackie mentioned, we don't anticipate that change for July 1st to be challenged in court. Like, it's using a very consistent methodology in decision making. We do, however, anticipate that January 1st change being challenged in court. And there have been a couple of groups already vocal about that. But prepare. You know, if we've not learned anything, you know, in the last year, things can change, right? So things are very fluid. So don't wait to the last minute, but have it ready to go. And then let's wait and execute closer to the effective date. So Jackie, what final thoughts do you have?
You know, I always go back to the market, right? The key here is that this law isn't the result of the government just deciding to pay more. It's the result of a significant rise in our pay market, an even more significant rise in the cost of living. We see this every day, right? So to ensure that our people are able to afford the cost of goods and services and to support themselves and their families, with the increase of inflation, our tight labor market, all of these factors have driven up the labor market that have resulted in this change. So, you know, this is such a good time to go back and say, wow, it's really important that I ensure I'm paying market rate for my people, right? I'm taking care of them. Pay equity is in line. And we're talking about all those other aspects around pay. We all know transparency is key right now. So let's really start exploring all of those elements. We are here to help. The compensation team, this is what we do every day for our members. So please don't hesitate to reach out. If you have a question about the classification of a position, let us help you. We're here. We're here to use as a resource. You have a team of people here supporting you, advice, Carol and Linda, our compensation team, our HR on-demand consultants that are on site with our members every day, our learning team, we all work together to support you. So whether it's this new FLSA ruling or anything else, keep us in mind as a resource for any change coming your way.
Awesome. Thank you so much, Jackie. So on the face of it, it sounds pretty simple, right? The salary levels are going up. You either have to raise your rates or you change the classification. But I hope what you kind of gathered from this today is that there's probably a little more to it than that. But we are here to help, and we do have tools. It does look like there have been quite a few questions, so I'm going to let Carol get started on asking some of them. I did see a note in here that we will try to take these questions and we will try to create an FAQ document out of them so that if we don't get to all of them, or if you need to reference them later, you will have them all in one place.
Absolutely. So, yeah, I've been capturing all those questions. So let's see how many we can get through. So the first question is, can I continue to pay impacted employees a salary after I reclassified them as non-exempt? Linda, I'm going to let you take that one.
Well, that's no fair, because the answer is yes. You could. There is a way that you can have somebody be salaried non-exempt. We don't generally see that there's a lot of benefit to doing that, and feel free to jump in, Jackie, if I'm wrong. But when you have a salaried non-exempt employee, you're basically giving them a guaranteed salary plus paying them overtime. So they really get the best of both worlds. So it's a really good deal for the employee, but I don't know the benefit that it really gives an employer unless you are in a situation where your work weeks fluctuate and you are really trying to give a set or a guaranteed minimum amount of salary to your employees each week.
All right. I think that was a fabulous answer, Linda. All right, so the next question, and we kind of touched on that, Linda did in her portion. Can one employee be exempt and another non-exempt, even if they have the same job title? And so as Linda mentioned, the answer to that is yes. Again, you want to make sure that you have some sound logic to why there is some variation in that classification. You want to make sure that it's not based in, preferential or discriminatory reasons. But if there's a logic to that, a sound business logic to that, yes, you can have two people, both with the title of buyer, one classified as exempt and one classified as non-exempt, and still be compliant with the FLSA. Anything you would add, Linda?
I wouldn't, other than look carefully when you do your analysis to see what makes the most sense, right? If somebody is just a little bit under the threshold, but you're going to be giving them an upcoming raise that'll take them over the threshold, it may make sense to make all the changes at one time.
Awesome. All right, so the next question is, the annual salary minimum, is that based on gross income? And so the short answer is yes. So they are looking at gross income for this minimum threshold. And then the next question kind of relates to the annual income. So can they be under the salary threshold during the year until commission or incentives or bonus are paid at year end? So Joni, can I get you to go back to the slide from Jackie's section that has all of those, pay changes that are happening? So you'll see that there is a weekly salary amount, right, that's listed, and that's going to be especially important for that highly compensated group, which we'll touch on with some of these other questions. But if you are supplementing that total annual compensation with 10%, commissions or non-discretionary bonuses, you can have them under that weekly salary amount so long as their total compensation at the end of the year matches that new minimum threshold. And if their commission or their bonus doesn't bring them to the new threshold, you do have to do a catch up. You've got to close that gap for them. So I think that's really important for those of you who are looking at, this up to 10% of the non-discretionary piece as part of the total compensation. You'll need to be mindful to make sure your numbers are at that minimum threshold by the end of the year. So Linda, Jackie, would you kind of add anything to that answer?
I believe then after the end of the year, you have one pay period to do that catch up.
Thank you. That's right. That's a great reminder, Linda. All right. So let's see. One of the questions was around commission that talked specifically can commission be considered as compensation if they're exempt under the outside sales exemption? Just as a reminder, the outside sales exemption was not impacted by this final rule. Only 3 of the exemptions were impacted under this final rule. There is the executive, the administrative, and the professional categories that were impacted. So anything that was under the outside sales exemption still remains as before. Now, in follow-up to that commission question, someone else said, if they are considered exempt under the admin category, can commissions still be considered as part of their compensation? And so Linda's nodding her head, right? Like Jackie is nodding her head as well. And so the answer is yes, up to 10%. So you'll see that slide that's up on the screen right now, that up to 10% is key. So no more than 10% of their compensation to get them to that annual threshold can be above the 10%. I'm not sure if that came out correctly. You guys may have to help me with my wording here.
Yeah, you know what, Carol, that I struggled with understanding that and trying to explain it, but it's 10% of the threshold, not of their total compensation, right? So it's really a fixed number, right? On July 1st, it's $4,388. They could make $500,000 in commission, but you can only count $4,388 as part of their salary to meet that threshold. And obviously we're not talking about outside sales. We're talking about the 3 categories that Carol mentioned: admin, professional, and executive.
You articulated that so much better than me. Thank you. All right. So the next question is, I just want to confirm July 1st looks like it's going to happen, but we're unsure of January 1st. And so all 3 of us presenters are nodding our head, right? Again, while we can't predict the future, we anticipate that January 1st may be challenged. All right, so here is another question for the panel. Can you raise the salaried non-exempt employees' work week to 50 hours a week instead of 40? And then pay them that new threshold of $43,888, and then anything worked over 50 hours paid at the overtime rate. So a couple of things happening there. Let's start with the first question. Can you change their weekly threshold to 50 hours instead of 40? Linda?
Sure. But if they're non-exempt, you're going to have to pay them overtime for the hours that they work over 40.
Yes.
If you change them to exempt, you don't necessarily have to pay for those hours, but we would want to keep in mind that you're not, when you change somebody to exempt, you're paying them for results of the job and not necessarily production. So you don't, typically we don't see in an exempt, at an exempt level, that there are prescribed hours that you have to work.
Yeah. So I think, Linda, you fabulously answered both questions, right? So overtime for non-exempt employees, even if you say their work week has to be 50 hours, the Federal Labor Standard Act says overtime for non-exempt is any hours over 40 in a work week. So you can't delay overtime to anything over 50.
Right.
All right. Another great question, is the salary threshold prorated for part-time exempt employees only working 30 hours a week? Linda, you want to take this one?
Yes, I'll take it. And the answer is no, it's not. That is a fixed amount that you have to pay, whether the person is working 1 hour a week or 70 hours a week. So you do have to keep that in mind. So a lot of times what we see is when people are in part-time positions, and Jackie, I think this is probably what you're most familiar with, those are the times when we really use that non-exempt classification on roles that would otherwise be exempt.
All right, so the next two questions are really around that highly compensated employee exemption. So this may take a village for us all to kind of answer for those on the call. So the first request is, discuss the HCE rules. How is an employee determined to be exempt under a highly compensated employee category? You'll recall Jackie kind of mentioned there are 3 tests, right? So there is that salary level, there is that duties test, and there's that compensation piece. When it comes to the highly compensated individuals, they have to first meet that box of the compensation. Right now it's 107,432. You'll see from that slide that in July, right, it's increasing to 132,964, and then again in January to 151,164. If they meet that highly compensated piece, they must only meet one duties test of either an exempt, administrative, or professional employee. So you recall whenever we looked at that executive and administrative exemption category, there were multiple tests that had to be met for the duties piece. For the highly compensated employee, if they meet the salary threshold and only one of those duties test, they can fall under this HCE rule. Is there anything, Linda or Jackie, you would add to that explanation?
I will say only that that applies very infrequently, because generally, if you've got somebody at that level, they're meeting all of the duties tests anyway. As a matter of fact, I can't even really think of a good example of a type of a role where that may even apply. But a common question that we've gotten over the last couple of weeks is, do I need to raise the salary level of my HCEs? No, you do not. Right?
Oh,
You do not.
okay.
Yeah,
That's
so
the piece that we've been struggling with, is if we have a manager, so they have a couple of direct reports, they are managing a division or a department, but they aren't at the 107. We were struggling with, do we have to raise them to that?
Right. As long as they meet the duties test, all the 3 bullet points of the duties test under the appropriate exemption category, no, you do not.
Yeah, so what Linda is saying is it goes back to some of that initial guidance to look at how you have your employees classified. So one of the tools in that toolbox that we've given you the link to is kind of an inventory of sorts, where you're outlining the position and which exemption category applies to that role. What we've seen with a lot of our members so far is that folks they had classified as highly compensated employees exemption really kind of passed the duty test for a different category.
Right.
So to Linda's point, like they really passed all the duties tests for the executive exemption. And so if the executive exemption applies, then you don't have to worry about these much higher numbers in those right columns, right? Like you would follow those numbers that are on that under the standard salary level, the ones on the left. So go back and assess why your positions are classified as they are and look to see if there is another exemption category that better applies to the role. All right, and then another question, what kind of notification or training would you prepare for July 1st? Is there anything available on the hub? Jackie or Linda, either of you want to take that question?
I don't believe we have anything on the hub right now that speaks to the different types of things to consider with training, but I think that we can easily make that part of our FAQ and give you bullet points on what to consider. I think when you do that is going to depend on your pay schedule, right? So if you pay once a month and you have to give one full pay period's notice before changes are made, you're going to need to make your changes by June 1st, so that by July 1st, you'll be in compliance. But if you pay once a week, you're not going to need to make your changes until the end of June. And we would encourage you to wait until the last opportunity that you have. But we always would encourage to do some training ahead of time, so people are prepared and this doesn't come as a shock. If in fact you see that you've got a significant population that's changing.
Yeah, and Linda, I think you actually touched on some of that as well. Whenever you talked about folks who may be converting from exempt to non-exempt status, when we talk about that training, it's really around like those timekeeping procedures. Where are they going to record their time? How do they record their time? Letting them know about those meal and break periods, going back to where Linda kind of called out personal devices, not working off the clock. So that's part of that training piece, is helping them orient to internal company policies and processes, as well as understanding what laws they need to be compliant with. So I think that's something you can incorporate into your training plan. And then for the communication piece, that notification piece, we do have a couple of templates out in the hub. One that does address a conversion from exempt to non-exempt, that kind of calls out a couple of items for them. So that link provided earlier will kind of help you in that. But to Linda's point, we'll include a couple of bullet points in the FAQs to help you with that training piece. And it looks like a new question just popped in that said, this applies to salary only, not hourly. So I want to remind you that it's about whether they are exempt or non-exempt under the FLSA. So Linda addressed the question earlier, can I pay someone salary if they are non-exempt? And Linda's answer was, yeah, not our favorite, right? But it is legal. So your focus isn't on salary versus hourly. Your focus for this rule change is whether they are exempt or non-exempt under the FLSA. So those who are non-exempt under the FLSA do tend to most often, but not always, be paid hourly. They are not impacted by this rule change. This rule change only applies to those who are exempt under the executive, administrative, professional, or highly compensated employee exemption categories.
Excellent distinction, Carol. Thank you. And it looks like we really are at the top of the hour. I think we got to most of the questions, but again, we'll put a document together and make sure that everyone has access to it on our hub, right? So we're going to end this with one final suggestion that you all take a couple minutes, go to your Catapult site, go to the member hub, and check out some of the cool new features that we have there. But again, if you go to the toolkit, you can easily get to this new DOL toolkit for you. We'll send a recording as well as, I believe, maybe a copy of the slides that we used today. Will all come to you after the fact. We want to thank you all for your participation and questions. If you have any other questions that weren't answered, that's what HR advice and Jackie, your compensation analyst, is here for. So feel free to give us a call and we'll help. Any closing thoughts, Tom?
Yeah, I just wanted to mention that as a reminder that Catapult does provide FLSA audit services. So if it's not something that you feel comfortable doing on your own, please reach out to us and we can help you.
Awesome. Well, again, thank you, everyone. Hope you have a good rest of your day.